As we've discussed, your rights to oil and gas are property rights. And you may remember from property class that you can lose your property rights by disuse or inattention. And so we'll talk about how that applies to oil and gas today. Loss of title. How title to your minerals may be lost. Well, the first way is by adverse possession. And I'll remind you of the elements of adverse possession. Second way is by abandonment. Remember, abandonment is what you do with personal property. So again, I've given the example of if you leave a bicycle in the middle of campus for 2 weeks, you might be said to have abandoned it. The liberative prescription is a way to lose title to minerals in Louisiana. So it's a unique feature of Louisiana law. Then many states have adopted Dormant Minerals Acts, which are basically designed for properties where nobody can tell who owns the minerals anymore, and so at some point you can lose those, and we'll talk about that a little bit. And then Marketable Title Acts, which are just general rules that apply to land titles, but of course can cause you to lose your minerals as well. Finally, Unclaimed Personal Property Act. Sometimes if you fail to make a claim to a royalty for a certain period of time, statute may have that swept up in an Unclaimed Personal Property Act. So which rules apply? Well, adverse possession would apply to your basic interest in minerals if you're in an ownership in place state. You'll remember that states like Texas, where we say that you own the oil and gas in the ground. In those states, we have adverse possession, which relies on trespasser action. So they do something to make a claim to your land plus owner inaction. And in just a second, I'll take you through the elements of an adverse possession claim, just so you can remember how that works. Abandonment. So in non-ownership states, we call them, which is, remember, a bit of a misnomer. Basically, in non-ownership states like Oklahoma, what we really say is that you have own the exclusive right to produce oil and gas from your land. You just don't own the oil and gas in place. In those states, we apply abandonment. And in abandonment, all we really need is owner inaction, but there usually has to be something more, some kind of unfairness or otherwise in saying that the owner still has it. In Louisiana, we use this liberative prescription, and that basically says that any mineral servitude, so anything that's just applicable to the minerals, automatically terminates after 10 years of non-use. So even if you bought the minerals, if you don't operate on them, start producing oil and gas for 10 years, it goes back to the landowner. And that's supposed to be, it sort of simplifies things in that that if nobody bought the minerals in the last 10 years, the surface owner still has it, if nobody's operated on it. Dormant minerals and marketable title acts, you have some examples of those in your book. Basically, they differ from state to state, and effectively, they're just designed to try and often they're in places where there was like an old oil and gas boom, and so people started selling mineral interests and inheriting them years and years ago, and now there are thousands of people who own the minerals on just one piece of land. You can't find all of them, and at some point we'll say if you're not using those minerals, and you don't make a current claim to them, they will revert to the landowner. One of the benefits of that, of course, is that as an oil and gas company, if you want to operate on somebody's land, you can just negotiate with the surface owner, not these thousands of fractional interest owners. But you can imagine they can be quite controversial, and some people might say that they were a taking under the U.S. Constitution if the act is basically saying, look, you're going to forfeit your property right in this property after some period of time. So as a quick reminder, adverse possession, remember, it's got to be actual adverse possession with exclusive possession. So, you're not you're not just sleeping in a corner of the property. You're treating it as your own. Has to be open and notorious. So again, this is kind of designed so that the true owner can know that you're doing this. You're not just sneaking in occasionally at night. You are claiming making a claim to this property, adverse and under claim of right. That means you don't have permission to be operating the property. It's not consensual. It is you have made a claim. This is my property. Then it's got to be continuous. You can't leave the property and come back, although it doesn't always have to be the same person. So if one person begins adversely possessing the property and then sells it to somebody else, that means they're in privity, and that means that you can tack that time. So if you come back 30 years later, there's been 3 owners treating this land as their own, actual, open, notorious, adverse, then they will have successfully adversely possessed it against you.